I think it's really hard to open your own practice when you come out of law school. I don't know why they continue to do this, but they don't teach you anything about business. It's hard to really understand how your business is probably going to proceed without having had any business education whatsoever.
Hey everyone, Bo Royal here, co-founder and CEO of Pareto Legal, a marketing agency that helps injury lawyers increase their profits with digital strategy, online advertising, and analytics. You're listening to the Pareto Legal Podcast, where we feature world-class attorneys, entrepreneurs, and legal experts. And today I'm joined by Joe Garrison, founder of Garrison Law, a Connecticut-based law firm that focuses on all facets of employment law. In this episode, we'll learn more about Joe's background as a leading employment lawyer in Connecticut and one of the most prominent employee rights advocates in the United States, and how Joe was able to establish and build his practice for over 45 years. Joe, thank you very much for being here today.
I'm happy to be here.
So, Joe, can you share a little bit about your background and what initially drew you to the field of employment law?
So my educational background is that I went to Wesleyan University here in Connecticut. And from there, I went to Cornell Law School. After I graduated from Cornell, a week after I graduated, actually, I got married at that time. And so it was 1968, a heavy draft year. And I thought maybe alternative to being in the draft would be to be in more of a different kind of public service. And so my wife and I went into the Volunteers for Service to America for 2 years, and I was doing legal work there, part of it in Iowa and part in Idaho, so it was interesting moving around the country. But I always wanted to come back to Connecticut because I liked it here when I went to Wesleyan, and we really wanted to live in Connecticut, so I did, and I joined the New Haven Legal Assistance Association, largely because that's what I had been doing for the 2 years after graduating from Cornell, working with people who needed lawyers but couldn't afford them. And so I was in that program for about 5 years. And during that time, I really took a lot of different kinds of cases, but I wasn't really involved in employment law. And when I decided to leave legal assistance, I joined another person, a partner who had been with legal assistance himself. We were good friends. And interestingly enough, early in our association, I had a client come in with an employment case. It was a race discrimination case. And it was an interesting case which went to trial. We won the jury trial. The judge didn't like the win that we had and actually moved to dismiss the case. And we took that up to the Second Circuit and won it, and came back and retried the case and won again, and won more than we had the first time. Anyway, that was obviously enough to get me pretty interested in employment law. So that started a career which has actually since then been really interesting and successful.
So between that specific case that really got you interested in employment law, and then to the time that you ended up founding Garrison Law Firm, what was that year gap? Like how long were you practicing employment law before you actually decided to go out on your own and found your own firm?
The legal assistance work had some employment components, okay, because a lot of people that are unable to afford lawyers, they still get fired from their employment, or they get something else happens to them that is an issue. Discrimination is clearly part of the agenda there. And so I liked those cases. I thought they were interesting cases, and I thought it was really good to be able to help those people out. I liked those better than I liked other kinds of cases. And so I think I got good at it at that time. And when I went out into my own practice, I wanted to focus on that, and if I could. And as I say, I fairly luckily early in the career in private practice had this case that was it was well publicized, and it was a good win. And I think that helped. But it's back in those days, there was no internet, and it was really different. And so, it depended much more on newspaper publicity and other forms of publicity, which nobody cares about now, but it made a big difference then.
Was there a catalyst that motivated you to go out and start your own firm?
Yes. I mean, I had always had an entrepreneurial background, frankly. I always wanted to do that. I always wanted to be, if you will, my own boss. And I didn't want to go with a large firm at all. I thought I could be successful because I had been successful in legal services, but it's a risk. Luckily, my wife was working, and that helped, of course, in the beginning. And it had always been a motivation. I always thought that would be the best thing to do.
It was always the end goal, basically.
It always was.
Start your own practice. And then can you talk about some of the initial challenges that you faced when you set up your own practice?
Yes. I mean, like I say, because the method of getting your word out was really much harder, because it wasn't, you didn't have all the communication that we have now, not by any means whatsoever. I mean, it was really hard. It was really a question of getting out to the people that you knew, and sending letters and things like that, and going to meetings and just showing up in a lot of different places and trying to make yourself somebody who people would be aware of. And in the beginning, it was more general for me because we were just starting, and my partner and I were just the two of us, and we really had to take a much more of a variety of cases. But the employment cases were the ones that I took. I took personal injury cases. I took a variety of other things too at the beginning, but I was always hoping to consolidate the practice more on the employment side.
Ironically, any attorneys just building their own practices starting out today, they need to start doing the same things as well. They don't have a large budget to start with to advertise on TV or billboard. They really need to rely on more of those grassroots types of tactics, like building word of mouth, tapping your network, handing out cards, going to networking events, things of that nature. So that really hasn't changed much over the last 45, 50 years. Obviously, the advertising mediums have certainly evolved and changed over time, but that's something that's held consistent, it seems like, is anyone just starting out really needs to kind of put in that initial legwork and get out there, make a name for themselves in a way that's not you can't do with an advertising budget or a marketing budget, right? You have to build that reputation slowly.
I think that's right in part, but it would really help if you saved up some money and you could actually hire somebody who really was an expert in marketing. Because lawyers aren't. And, we think we're pretty good at most everything, but that's really not true. And marketing is one of those things that I don't think lawyers know very much about at all. Our firm obviously uses a marketing firm, and they are a huge help to us. I think if a lawyer going out, and particularly if the person's going out to be a solo practitioner, I think it would really be helpful to have somebody who was skilled in marketing assist them.
I agree. So much so that I built a business around that.
I know that. I'm sort of giving you an advertisement.
I appreciate it. This is actually a perfect segue, because I wanted to ask you, I wanted to talk more to you about the marketing that your firm has done. Is there anything in particular that stands out to you that was very effective in attracting and retaining employment law clients?
Yes. It's interesting. Our firm, for a number of years, has used a questionnaire to basically to deselect potential clients, frankly, and because we have an awful lot of people that come to our firm wanting legal assistance, and we can't in any way possible service all of them. First of all, whether people will return it, because if they won't return a questionnaire, they're not going to be a good client. That's almost a sure thing. And then if they do, then it's a good question of how do they how do they present themselves and how do they present their case and so on. And we learn a lot through that, and it helps us a lot because the truth is, in employment law in particular, I think you really have to select clients very carefully. You have to determine, whether a person really was wrongfully treated, as we find our clients have been, or they think they were wrongfully treated, but they really weren't. Or the law doesn't protect them. That's another big factor, because the law doesn't protect everybody by any means. And so we need to use the questionnaire to make choices like that. The real answer is that when we get the questionnaire back, we also ask, how did you get referred to us? Or how did you learn about us? And the answer to that in so many cases is the website. Mm-hmm. It really sort of has surprised me. And that's why we have a marketing firm in many respects, because I think our website is really quite excellent. And I've looked at a lot of other lawyer websites because I make a lot of referrals to other lawyers in other states. And sometimes I actually don't make the referral that I would want to make because the website is so bad or it's so sparse. It doesn't tell you anything. And so it's, to me, that's a really important component of building a law firm.
I completely agree. I love the first part of your answer, just talking about the questionnaire. Really, the way to think about that is, you have to be very intentional in terms of the cases that your firm accepts. And I think the more clear you can be in terms of the types of cases that you want, the specific criteria that you're looking for when you're going through that intake process, the higher the likelihood that you're going to be able to build a sustainable practice off of that. Because the worst thing you could do is bring on a case that is going to be thousands of hours of work, or it's going to, the likelihood of it, coming to a successful outcome is very low. So I think that's spot on. That you have to have a system in place that effectively captures the cases that you ultimately want. That's square one. And then I'm going to totally agree with you on the second point, which is, the digital presence. A website is effectively your law firm's virtual storefront. And it's the first impression that people have, when it comes to interacting with your practice. And if you don't have that in order, you're not clearly, articulating what your value propositions are, your successful settlements, your team, your history, things of that nature. You're going to give your competitors an opportunity to capture some of that traffic and audience. So,
yeah. And the other interesting thing about the questionnaire is that we use it for everybody. And when even high executives return it, even they say that it's important to have understood what it is that we're looking for, and really think about what really happened to them, and then express it. That
questionnaire, is that typically sent before you officially retain the client?
Yes.
Okay.
That's right.
Excellent. So I want to talk a little bit more about the legal landscape. You ran your practice for 45 years. I believe, if I read properly, Joe, you retired back in 2023, at least from dealing directly with clients, correct?
That's right.
Okay.
Right at the end of 2023.
Right at the end of 2023. Congratulations, first off. That's amazing. You've obviously been in the legal field for quite a long time. How have you seen the legal landscape for employment law, or just in general, evolve over the years? And what are some of the most notable changes that you've observed?
The most notable change, I think, is that there are statutes that are passed almost every year, both state and federal, that affect employment law. And sometimes, you're always wondering which way is that going to go. Luckily, I believe many of the statutes that have been passed, in Connecticut anyway, have been pro-employee. Some of the larger ones, like Title VII, for example, federally, those have not been changed, as a law has been able to be built with stepping stones that have been useful, and Title VII has been a strong statute. That's what happens almost all the time. The other thing that happens is that for whatever reason, the United States Supreme Court takes a lot of employment cases. And, because they take a lot of discrimination cases, and it's a fairly constant factor every year that they're going to have 2 or 3 that are fairly important. And you always wonder what's going to happen when a case that was Reeves, was the name of the plaintiff, came to the court. It had to do with the kind of evidence could be produced to show discrimination. And frankly, if the court had decided Reeves the other way than they did, it would have probably decimated employment law. So we have those things that we think about every once in a while and think, oh my God, are we going to have a practice after this case when they took the case? But the Supreme Court has been surprisingly good. Even this court now, which is much more conservative than earlier courts, they don't stick with precedent, in my opinion, in all cases. That's for sure. They take some and then that are precedential and they overrule them, but they've been in other areas than discrimination. And so I think that in general, the federal law has moved forward, often very slowly, but at least it hasn't moved backwards over the course of time.
In favor of employees.
Yeah, I think it's not total. It's not by any means totally in favor of employees, and many of the statutes are fairly ambiguous, and depending on where you live in the country, the judicial system is simply different. Some states it's really hard to win an employment case. Some states like Connecticut, it's much more favorable. So there is a difference, that's for sure, geographically. In general, employment law has become a more attractive area of law for a lot of people, and you see the field expanding all the time.
Right. Well, I guess, would you consider yourself an early adopter then? You were kind of ahead of the curve before more and more attorneys wanted to move into employment law?
Yes, I was. Some people here in Connecticut call me the founder of employment law. I don't know if that's actually true, but I was early, yes. We have a national organization called the National Employment Lawyers Association, and I was an early president of that. So I got a national exposure fairly early, and that was helpful too.
Excellent. I want to pivot for a second and talk about client relationships. So obviously building strong relationships with clients is essential. What approaches have you or your firm used over the years to ensure that your clients are feeling heard and supported throughout their cases?
So I think that a really important thing to do is to keep in touch with your clients. And I think that some lawyers make mistakes because they take too many. And I think that sometimes happens early in a practice and before they've really tried to figure out, how do I really make this work? The saying is, and I think there's some accuracy to this, that if you have one bad case in every 10 cases, that one bad case of 10 is going to take up like what 6 good cases take up in terms of time, because you're just going to have all these problems that you have to deal with that you shouldn't have to deal with if you've selected the case correctly. So I think that clients can actually turn also, it's not the client, it's the lawyer. But if the lawyer doesn't keep in touch with the client pretty clearly, obviously, I think, would lose confidence in the lawyer. What's going on with my case? I can't figure out. Nobody talks to me about it. I think that's really one of the most important things to do. It doesn't matter if you're even saying anything substantive. If you just call people up and say, here's what's going on right now. We're stuck in the court. There's a motion the court has to decide. And, these judges take a long time. Sometimes it may take a few months. I will keep in touch with you and let you know how it's going. But right now, that's where it is. It's just stalled, and there's nothing we can do about it until the judge decides. Everybody thinks that's fine because it's the truth, and people understand that the legal system takes time. But if you didn't call them at all during the 6 months, 8 months that the judge is deciding, then they really start to worry. And, people don't feel that confident a lot of times about calling up their lawyer saying, well, what should I do? They're kind of embarrassed to do that. And so it's up to the lawyer to be proactive in that kind of situation. I think that's extremely important. Another thing I think that's important in employment cases anyway is to do something fairly quickly, something that really starts the case off and that can move it fairly quickly. Now, you don't always want to do that, but in the general case, yes, it would be helpful. If there's a letter that needs to go out, try to get that composed reasonably quickly. If there's information that you need, tell the client that and have the client start to move on that. That's often the case, by the way. Mm-hmm. And it's just something like that has the client thinking, good, this lawyer must think something good about my case because they want me to do something, or they're going to do something for me. And they're going to do it reasonably soon, so I get some preference, and that's good. Another thing I think that is hard to do in the beginning when you start off your practice, but it gets you get more acquainted with what you should do as you go on, is to actually understand what the needs of the clients are and be prepared to help them get those needs. A lot of people don't want to be in litigation. I mean, I think it's 90% of the people, maybe higher than that, do not want to be in litigation. And, trial lawyers love litigation. I loved it. I thought the best thing I could do in work was to be in jury trials. I liked it a lot. But, that's not really the same for the clients. Now, if they understand they have to go to a jury trial, and then they get pretty interested themselves. But when you come in, they are not thinking, I want to be in court. They're thinking just the opposite. And so you need to figure out what needs do they have and how can you solve that in a way that they would like to have it solved. And that's not easy. You really have to talk to people carefully about that. And you really have to, kind of get that information in a way that's somewhat subtle. You don't want to ask a person, well, do you want to be in court? Because you're never going to get an answer that they really believe is a truthful answer. They're going to say something that they hope will please the lawyer. So understanding their needs is something that really is hard to do, and it takes a lot of practice. And for lawyers that are going into a firm, it's a huge help for them to be able to see how the partners deal with new clients and so on. And that happens in a lot of bigger firms and so on. And here it does too. Our firm has 7 lawyers, and when we have a new one come in, we always have that lawyer listen in on conversations that we have, first communications that we have with clients and so on. We always have that happen. And it takes a while before we will allow a new lawyer to do a consult all by him or herself. So those things I think are all important things that build relationships with clients and keep the relationships good.
A lot of great insights in that response. So to dissect, the ones that I heard, being selective, going back to one of the things you said earlier in the podcast, making sure that you're saying yes to the right clients is important for establishing proper relationships, making sure that you're maintaining some regular cadence of communication with your clients is incredibly important. Making sure that you understand the needs of the client is very important as well. And not only understanding those needs, but addressing them up front. You also said something along the lines of taking action early on in the case to almost establish some initial trust. Is that a good way to summarize it? Like showing the clients that you're moving the case forward fairly quickly. Is that a good?
Yes,
yeah.
Sometimes you have to because there's statute of limitations or something like that. So, but in the normal case, you're not confronted with a early statute of limitations issue. But it really does help somebody to think that they are being valued as a client to have something happen fairly quickly.
Right.
So that they're not thinking, well, I'm in the back of the line. It's nice if they think that in the front of the line, even if it's for a short period of time, that they will be in the front of the line, because if you keep in touch with them later, you can tell them why there are delays and so on, like I said earlier.
So for any attorneys listening to this right now, I think the insights Joe just shared really should be incorporated into most law firm operations. So making sure that you have, again, clear accept reject criteria on the cases, making sure that you have some consistent cadence that you are touching base with your clients, giving them updates on case status, asking them how they're doing, things of that nature, making sure that you are being very making sure that you're taking the time to understand their unique needs and addressing them accordingly. And then, like Joe said, if there are some quick wins that you can deploy early on in the case, make sure that you're doing that. Make sure that you're communicating those wins to your clients. Joe, I want to ask a little bit about advice that you would give to young attorneys. So specifically, what would you tell young attorneys who are just starting off in their careers in employment law or any area of law for that matter, and are considering opening their own practice? What advice would you give them?
I think it's really hard to open your own practice when you come out of law school because you have no idea. Law schools, I don't know why they continue to do this or continue to omit this, but they don't teach you anything about business. And they don't teach you anything about running a business, that's for sure. And I think that's a really strong omission. Schools ought to be a lot more interested in than they are. And so I think that it's hard to really understand how your business is probably going to proceed without having had any business education whatsoever. So if you can get some, I think it's important to do that. Unless you are sort of compelled into it, I think it's not a great idea to go out and try to open up your own firm and be your own, a solo firm. I think it's just really hard. I congratulate a lot of people who have done it and managed to be successful about it, because I think they've overcome a lot of difficulties, and good for them. And it's nice to see. On the other hand, there are a lot of people that come out in that situation. And when you look at sort of general like earnings of lawyers, I mean, there are a lot of lawyers that earn less than hourly workers, and it's just because it's really hard to establish yourself in a market that is already maybe over-lawyered or something of that nature. And if you go out into a place that is not over-lawyered, well, maybe there's a good reason that it's not. It's simply trying to do this without any expertise in how to, get yourself exposed and how are you going to be able to attract people. It's just a really difficult thing to do. So I think that in the employment field, this is I think this is a little odd for me to say, but I think it would make some sense if you looked for jobs more on the management side, because those are the ones that really are hiring much more often than those of us who are doing the employee side, because your management side people are doing consultations all the time. A statute changes, for example, and nothing happens on the employee side, but in the management side, there you have to, take your clients through what these changes in the statute are going to mean to the business. So there's a lot of work on that side, a lot more potential work. And so I frankly think that if people are interested in employment law, that's a good place to look. And then if you are in a management law firm for 3, 4, 5 years and you like the work, stay with it. If you don't, then you are much better prepared to come out and do work on the employee side. First of all, you have a better resume to maybe be hired by an employee side firm. But secondly, even if you don't, you have the knowledge now so that you can go out and you might be well off by getting referrals from the firm that you worked for. So there's some way of really starting yourself off that way without just coming in cold and not knowing anything about how to do the business. The other thing is that there are a lot of organizations now that can be very helpful in employment law. I said the National Employment Lawyers Association, which is really important for plaintiff lawyers. And I think everybody who does that, the law on the employee side, should actually join the National Employment Lawyers Association, or at least the state counterparts, because there are a lot of state and even local counterparts to that. There will be like the Connecticut Employment Lawyers Association, the New York, most every state now has organizations like that. And it's like all of a sudden joining a big law firm in a sense, because when the meetings occur, they often occur for substantive reasons, and there'll be discussion about areas of employment law that are really helpful to for people to learn. And in general, it's the people that have some expertise that are doing the presentations. And so, join those organizations and be active in them. If you can, research what actually works for you. That's why we use our questionnaires, for example. Our questionnaires are a great source of research for us. And they tell us what works and what doesn't work in many situations. So that, when you're thinking back over your cases, what happened in your case, think about it in terms of research, if you will, for what can happen in the future. And lastly, I do think it's important to spend some money on marketing. I really do, because that's going to expand your firm in all likelihood a lot faster than it would but in any other way. So those are the things that I think I would give advice for younger attorneys who are just starting out.
So much good advice there. I have a few more questions, Joe. I want to look ahead to the future and talk about emerging trends. So like specifically, what emerging trends do you see in employment law that attorneys and firms should be prepared for in the coming years?
I think there's going to be more growth in employment law itself, because statutory changes really do occur all the time. And so I think that this will not be an area that is going to disappear. It's going to be an area that has more growth. And it's an area that concerns everybody all the time. And so, there's no reason it would get smaller. But I think the growth of statutory claims is going to be, again, more important in the future. Another important trend, I think, is the change from about who is a decision maker, if you will. It's the push that is toward arbitration of employment disputes or mediation of employment disputes. I saw this a while back, so I worked with the American Arbitration Association when I was more involved with our national organization, because when I was the president of that, the American Arbitration Association was interested in expanding their employment expertise and availability. And so they asked me if I would join the board, and I did. I had found it very interesting because it is an organization, the AAA is an organization that really is good at expanding what they do. And so whether you think it's good or bad, whether you think arbitration is a good thing or a bad thing, it doesn't matter much what you think. These organizations are pushing to get more business themselves, and they're good at it. So I think what is happening is there is much more of an emphasis on how to arbitrate and how to get into how to be successful in that field than in litigation, than in court. And what are the differences? Because there are significant differences. I have become an arbitrator myself, and it always surprises me sometimes when I'm chosen as an arbitrator, but I do obviously think I'm a fair arbitrator. and I've had some very interesting cases as an arbitrator. And I have done a lot of mediations as well, because mediation is the other area that I think is really expanding and is a trend that exists now, where 10 years ago it didn't exist at all. And I mean, maybe a little bit, but 5% of the cases maybe were mediated, and then it got bigger and bigger. Now it is really important. Now, when lawyers are coming to settle cases, they are almost always, it seems, okay, let's do this with a mediation. And so, finding the correct mediator and so on is really an important skill now, which didn't exist in just a few years ago. It's been a significant growth in a short period of time. And that's because I think people have found that they settle cases when they get together.
Hmm.
And, it's so much easier. The clients are with you at the time, and you're coming into a mediation because that's the point. You're there to settle the case. And so it really has now taken a predominant place in employment cases, and people really that are doing employment law, they need to learn about how to mediate. They need to learn about how to arbitrate. It's an area that has not been really explored very much, the teaching of those things, but it needs to be, and I think the bar is catching on to that now, and they're doing more of it. I think it's important for lawyers that want to be in employment law to really learn about those two areas.
Super interesting. Joe, I have one final question for you. You, as we've mentioned, you owned, operated Garrison Law for 45 years. You have a ton of experience. I wanted to ask more of a personal question. How, over the years, have you balanced the pressures of running a law firm and dealing with all these clients, balance that with maintaining a healthy personal life?
I am a person who has always believed in vacations, and when we started our law firm, we did a partnership agreement and sort of employment agreement with people that we hired, and we always put in writing that they were entitled to 6 weeks of vacation as a starter. That it was when I tell people that, they're actually nobody believes it, but it's true. And here's what this was really kind of interesting too. Earlier in my career, when we're not doing this now, and I'm not sure why we stopped, but at any rate, we had sabbaticals in the law firm, and that was usually 2 or 3 months off at a time. And the phenomenon that occurred was really amazing. It was that at the end of the year, when we looked at the productivity of the lawyers, the people that took sabbaticals often brought in more income than the ones that didn't. And that wasn't consistent, but it was pretty common that would be what happened. And I think it was because when people were, I know this for myself because I took 3 or 4 sabbaticals myself. I always wanted to wrap everything up before I went on sabbatical so that, I didn't have to hand a client over to another lawyer, or I didn't have to burden another lawyer with a case that I, had gotten to a certain point and something had to be happening or something like that. That was something I didn't want to do, and neither did any of the other lawyers. I think that's why it happened. So I was very productive in those years myself, and I wasn't surprised that this was a phenomenon that occurred with almost everybody. Not always, but it was quite interesting. If people get 6 weeks off, what I think happens is the same thing. If they're going to take 2 or 3 weeks, they want to get things done before that, because you don't want to have to hand things over to other lawyers and say, here, can you handle this for the next 3 weeks? That's not easy for somebody else who's got a full caseload to all of a sudden, take on something that you had. So I think what vacations do is they encourage that mentality. And then when people go on vacation, it's really great because they really do get refreshed. And so I was actually a very good person to look at myself. I was an example of what happens when you take time off, because I like taking time off. I enjoyed it. The other thing I think to balance practice is obviously to get other help. And I would say that if you are, if you can't afford to have another lawyer come in, which is an expensive proposition a lot of times, how about paralegal? You get a really good paralegal, you really get a lot of help. How about thinking about a contract lawyers? A lot of lawyers are out there that are contract lawyers now, and they'll come in and do a specific project or something like that for you. You can think about that. We don't do that very much in our firm, but we do have excellent paralegals in our firm. You might hire an associate. I mean, these are things that can help to balance personal life with running the law firm. The idea that you can run the law firm and do the law all the time is really, really hard. I have a relative that I think practices something like 70 or 80 hours a week, and I mean that's just you can't keep that up, and it's not. I don't think it's very healthy, and a lot of lawyers do that, and you see it all the time in big firms that this is what they do, and the benefit of that is supposedly that okay, you're going to earn a lot more money. Well, maybe. But if you bring it down to an hourly rate, it's not quite so attractive. And the last thing I would say here is that, like I was talking about with clients and understanding their needs, you need to understand yourself and understand what your own needs are. And if your own needs are okay, you can work all the time. That's fine, and do it. But most people don't see that way if they really think about it. And if you think about why am I having trouble going to sleep at night? Why am I having trouble, enjoying myself? Why can't I ever do anything outside? Start looking at yourself and what your own needs are, and starting to do. When you do that, you may well decide some things that I've thought were important here in the law, doing the practice of law, are not quite as important as keeping myself healthy and keeping my work fun, and that kind of life is a better life to lead than one where you're stressed out all the time and nothing is attractive or fun.
Well, that's great advice from someone that practiced law for as long as you did. The fact that you were able to own and operate a business for as long as you did clearly is a testament to your ability to take care of yourself, bring on the help to focus on areas of the firm that maybe you weren't as adept in. I love the 6 week sabbatical, or rather the 6 weeks of time off that all your employees get. I think that's amazing. And Joe, I really appreciate your time today. This has been a super insightful conversation. How can our listeners learn more about you and your firm?
They can look up GarrisonLaw.com. That's an easy thing to do, because we're on the internet, of course, and then you can find out all about the firm because you get right to our website. So that's the easiest of all. Now that you can just go on the website, that really is the easiest. And if anyone wanted to contact me, I'm still doing arbitrations and mediations. That's all. I'm not doing client work. But if people wanted to contact me for that, that's fine. And look at Garrison Law and you can find out how to do that. I think that's probably the best way to go about it.
Excellent. Joe, thank you again for joining us today. To our listeners, thanks for tuning into this episode of the Pareto Legal Podcast. We will see you next time for another episode.